Good morning, Mr. Sarmiento.
Ese señor Sarmiento.
You were,
Bien, señor Sarmiento.
Buenos días.
you were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine.
Dólares de
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Si no puede ocupar uno.
Yes, Judge.
Try to go slow.
Yes, Judge.
Más escuchen.
On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know. He didn't say he know he stole it. He just didn't know him. Did not get
So
permission.
you're telling me that he's in a car, he doesn't know the driver, and
Right. The complainant just said that in regard, he did not know the defendant, did not give
I
permission.
understand that. I get that. But so he's
Wait a second. A passenger in a car with no connection to the driver is getting hit with criminal trespass. This is where legal nuance matters. Trespass usually means knowingly entering somewhere without permission, but can just sitting in a stolen car count. Viewers, what do you think? Overreach, or is the law clear enough?
he's a passenger in a car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man, you know,
So the trespass was the driver driving into the area and he was the kind of.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was. One moment.
a scratch on the hood.
Signs of theft that would lead a reasonable and prudent person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. But I thought you also said that the driver and.
No, Your Honor, and it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there is enough there that a reasonable person would believe
That the
he's in a stolen car.
Stolen, yes.
So the steering column, was it?
was broken, and the officer said that in a manner only a screwdriver could turn the vehicle
Pensé que
on.
nomás un desarmador podía apagar el vehículo.
See, I don't know, because when I was young and dumb and 17, and, my friend had a CJ7, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
They
Judge.
always broke down. They always had a problem. We always, Jimmy rigged it as well,
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
No difference.
That goes to the element of without, for the criminal trespass, it goes to the, with, knowledge that it was,
Nah, no, I'm sorry. I'm going to find no probable cause. I'm sorry.
Que no hay razón probatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir. Yes, sir, you're charged with theft, aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 12th, 2025, the officer responded to an HEB in Harris County, Texas, in regard to the theft of an employee. The officer made contact with the complainant, the loss prevention investigator. The complainant stated the defendant was an employee of HEB, and the loss prevention employee was notified by a store manager that the defendant was taking Red Bull into the pharmacy without paying, drinking the Red Bulls, and then throwing it away. These acts were verified by video, and the complainant researched the defendant and noticed that when the defendant left his shift, he would have a bag of unpaid grocery items, would select items throughout the store, bring the unpaid items into the pharmacy, wait until the end of his shift, bag the products, and then leave the pharmacy without attempting to pay for the merchandise. The complainant observed the defendant take items without paying in 7 different days. The total was approximately $368.38.
All right. Sir, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to any HEB. Do you understand? If you violate these conditions, you pick up a new case, I'm going to put you in jail. No more PR bonds. You understand, sir? Are you working now? Do you have an income?
I am studying for my board exam. So no,
Studying for board exam for what?
actually,
This is the part that stings. He says he's studying for his nursing board exams, and now he's facing theft charges over Red Bulls and groceries. Judges see this a lot. People tanking their future over low-dollar theft. Quick poll. Should a career dream survive a mistake like this? Or should consequences be swift and hard?
Really? It's not a good way to start, sir. Really. Look, I'll give you a lawyer today. Don't pick up any new cases. You got to understand that you got your future ahead of you, man. You want to be a nurse and now you got, come on. Really? I need you to fill out an application for me. Fill it out. Let me take a look at it. I'll give you a lawyer today. Just make smart moves. It's not hard, really. Come on.
Judge, was that state sponsored?
Yeah. Do you mind filing knowing back HEB, please? Any HEB.
Yes, Judge.
All right, Judge, counsel is approaching on page 7. Hernandez, come on up.
Hi, good morning. Hi.
Assisting Joseph Ruiz today.
I'm sorry?
I'm here assisting Joseph Ruiz today.
Okay, for sure. You are Joaquin Hernandez. Mr. Hernandez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to 7000 Gulf Freeway and another officer had advised that the defendant was asleep in the driver's seat of the vehicle. The vehicle was on and running, and the officer observed a container of beer in plain view in the center cup holder. The officer made contact with the defendant.
Drinking while driving?
Yes, Judge. And the officer observed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and the defendant admitted to consuming beer, but did not state the amount. The officer observed a 12-ounce Michelob Ultra cold to the touch and a plastic bag labeled Margarita to go with a straw sticking out of it, mostly consumed, and an open pack of beer in the back seat. The standard field sobriety tests were performed, HGN 6 out of 6. Walk and turn and one leg stand were not performed due to the defendant claiming he had one bad leg. The defendant was read the DIC and declined to provide a sample, and a blood search warrant was signed and executed.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has any prior DWIs, please?
Yes, Judge. I see no prior DWIs.
I would venture a guess that it's damn elementary that you're not supposed to have alcohol in the car. I am now taking away your privilege to drive. You will be signing an affidavit with me today, promising me you're not going to drive, and I don't give a rat's behind what is going on in your life. If I find that you drive, and I don't care if there's a burning building and you have to save 50 children, I can have a contempt hearing. And every time you drive, you can be facing up to 6 months in jail and a $500 fine. Do you understand? Do not drive for any reason. If you have a problem with drugs or alcohol, you better address it, because if you don't, I will do it for you. And I promise you're not going to like the way that I do it. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find anything, you're going to stay with me. No more PR bonds.
Your Honor, will he have the opportunity to have an interlock system on his vehicle?
No, he can't drive. I'm not going to let him drive. I mean, he's got multiple open containers, all have consumed allegedly. No. I mean, and I would think that, it's a privilege. And if I get that he understands the awesome privilege at a later date, come back and we can talk. But at this point, no. I will have you come up here, swear to us that you're not going to drive. After that, I'm going to get you the Victoria sign and reset. After that, what is your name, please?
Takia Smith.
I'm sorry?
Smith.
Ms. Smith. You will get to Ms. Smith where she will give you your bond conditions. After that, you'll be free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games, you pick up a new case, you endanger my public, I'm going to revoke your bond and I'm going to put you in jail. Do you understand? It's not hard.
Judge, when we return on March 19, is there a possibility that we can present evidence to the court to permit the interlock?
I am always all ears, but at this point, with all that's in that car, no. But come back at a later day, show me, because it is a privilege. It's not a right. You want a right? Take your Dodge Patas and take, but it's an awesome privilege, and that's what it is. Show me how much of an appreciation, proactivity goes a long way, and then we can talk. All right? Yes, ma'am.
Judge, just really quick, tracking no drugs, no alcohol, is it random related?
Please, on all DWIs, Randy Days.
And
Yeah.
it's public device or not?
No,
Okay, right.
no. It's a first.
All right, Judge.
You said
next is page
you said it's a first, right?
Rand,
Two first?
come on
Okay.
up.
Morning, Mr. Garcia. Sir, you were charged with unlawful carrying of a weapon. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 9th, 2025, officers were dispatched to a disturbance with a weapon at a Boost Mobile business in Harris County, Texas. The officers were advised that two suspects were trying to rob the store, one with a handgun and in a wheelchair. The officer observed the male matching the description inside the business, and the defendant turned as if he was going to leave. The officer asked the defendant if he had any weapons on him, and the defendant stated he did not have any weapons and that he was confused as to what was going on. The defendant agreed to the officer patting him down for weapons and immediately began reaching into his pockets, claiming he was going to retrieve his wallet. The officer observed the defendant to have an unholstered black handgun on the right side waistband tucked between his shorts, and the defendant claimed the handgun was his sister's, was borrowed for safety, and the holster was in his sister's car.
So you said they were robbing the place and
He was reported to be involved in a robbery, and that's what the officer was.
they charged?
They charged him with, no, just the possession of PCS and then the unlawful carry.
Mr. Garcia, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using illegal drugs, any kind of alcohol, I will put you in jail. No more PR bonds. As it stands now, you're on felony probation. You've now picked up a case with us, and you have a felony possession case. Is there a co-defendant in this case?
Yes, Your Honor. There actually, no, Your Honor, there's not.
You said
They allegedly had two suspects, but the officer only made contact with the one defendant.
you're not to be in possession of any weapons, no alcohol, no drugs. Do you understand?
Yes, sir.
Tell me, do you need a lawyer appointed to you today?
Yes. I'm getting one, but not right now.
I can
So yeah.
now if you want. But don't pick up any new cases. Don't be a danger to my community, Mr. Garcia, because I'm going to tell you now, I'm going to protect
I was
my
buying a phone.
Stop. Don't say anything. Just, I want you to know that I'm going to protect my community at all costs. Do you understand?
Yes, sir.
I don't know what happened. I wasn't there. We got to wait for the evidence to come in. That's going to show us whose side is correct. I don't know. We'll get there. But just while you're out there in the free world, make the right moves. Because if I see you making wrong moves, I have only one place for you. Do you understand? Can you reach out to the Mac for Mr. Garcia, please? All right, so for now, I'm going to have you sign a receipt, Victoria. We'll have you get with Miss.
This judge is literally laying down the law. When she says, I have only one place for you, she's not bluffing. For repeat offenders on probation, even one bad decision can be a fast lane back to jail. What's your take? Tough love or just tough?
For your bond conditions, and then I'll have you take a seat in the jury box. Please. You are Miss Tijerina.
Yes, sir.
Ma'am, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 11th, 2025, the officer observed the defendant's vehicle bearing an unreadable E-tag at the 6900 block of Spencer Highway. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The defendant stated she was aware the E-tag was unreadable as it was waterlogged from being so old, that the E-tag was expired as of November 2024, and that her license plates were at home but not yet on the motor vehicle. The officer confirmed the defendant was operating the motor vehicle with the wrong license plates and observed no proof of financial responsibility for the vehicle. The officer observed slurred speech, red glossy eyes, and a strong odor of an alcoholic beverage. The defendant stated she was coming from a local bar, had consumed a bucket of Michelob Ultra beers, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and attempted a breath. The defendant attempted to provide a breath sample but was unable to complete the test. A blood search warrant was signed and executed.
Did you say she did field sobriety test or no?
She did. Would you like me to read them again?
Yeah.
HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4.
Mr. Kitty, I'm going to find that there's enough probable cause to go forward with your case. Can you see if she has a valid license?
It's eligible, Your Honor.
Okay, I'm now placing a restriction on that license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. You're also not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming, I'm going to revoke your bond. I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
And Judge, we're fine with the random testing. She did already let me know of a scheduled trip that she has. So can we let pretrial know those dates?
You can go on your trip, but understand you're still not to use. You're going to get tested as soon as you get back. If you test positive, it's not going to go well for you. Do you understand? I
Yes,
don't
sir.
care where you are in this world. You're still under bond condition in this court, not to use. Don't get in trouble. Make wise decisions, because if you don't, there will be disastrous consequences. And while you're out there, if you're driving, you're not allowed to unless it has an interlock on it. Do you understand?
Yes, sir.
Okay. So yeah, let Ms. Smith know about the travel, so that way.
I don't want her to get
knows.
violated this.
So you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Casey, and she'll tell you when you have to come back to court. If she tells me that you've gone AWOL, she can't get a hold of you, I'm going to revoke the bond. Do you understand, man?
Yes, sir.
All right. I'll have you sign a receipt with Victoria. We'll have you get with Ms. Smith for your bond conditions, and then you're free to go. Thanks, guys.
Thank you, Judge.
Have fun tonight. Mr. Gomez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to the 6800 block of Highway 225 within the city limits of Deer Park for a sedan stationary in lane 2 with a missing front tire. The officer observed the defendant in the driver's seat slumped over, the vehicle to be in drive, and the defendant to have his foot on the gas. The officer observed damage to the front right of the motor vehicle and the front right tire to be missing. The officer had to force entry into the vehicle to check the defendant's welfare due to the vehicle being locked. The officer put the vehicle in park and turned the vehicle off. The officer called out to the defendant, shook his arm, and administered 4 to 5 sternum rubs, and the defendant then slowly woke up and was unaware of what was occurring. The officer observed slurred speech, red glossy eyes, and a strong odor of an alcoholic beverage, in addition to unsteadiness on the defendant's feet. The officer observed a buzzball chiller and beatbox alcoholic drink on the front passenger floorboard, both containers empty. The defendant stated he drank 6 beers earlier in the night and thought he was still in Houston. Extended field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to provide a blood sample.
Are you telling me that there was alcohol while he was driving?
They just found empty containers. There's no facts indicating.
Okay. Does he have a valid Texas driver license?
All right, Your Honor.
Please. And any prior to be honest, you can run an NCIC. Mr. Gomez, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I'm going to revoke your bond. I'm going to put you in jail. No more PR bonds. Do you understand?
Your Honor, no prior DWIs and life is eligible.
If you don't have liability insurance coupled with that license, then you're not allowed to drive. That's also a condition of your bond as well. Do you understand? Do you have the ability to hire a lawyer?
No, sir.
Do you want to apply for an appointed lawyer?
Sir, the thing is, I'm actually on probation for a different
Stop.
charge. So,
Just don't. All I want to know is you want a court-appointed lawyer.
yes.
Okay. I'm going to appoint you a lawyer today. Just don't say anything. I've got a bunch of DAs here. Whatever they say, they can use it against you. I'll have you sign a receipt, Victoria. We're going to give you an application. We will eventually meet with Ms. Smith, and then we'll appoint your lawyer.
Yes, sir.
Okay? Leave.